This is a lecture from Open Tuition. For the free lecture notes that go with this podcast, please visit opentuition.com.
Page 77, chapter 11. I mentioned to you, I think it was Wednesday, that your examiner has indicated that it's highly likely that there will be a question on directors in each exam. It's a big area. It's an important area. So there's a good chance that directors and or officers will be asked. Now, do you remember intrinsic aids to interpretation of statute? Do you remember intrinsic? We had margin notes, the title of the statute, the Anzac Restriction of Trade Use of Word Act. We had the preamble, but also we have the definition section from within the Act itself, where a section within the Act will say, for the purposes of this statute, these words shall have the following meanings. And within the Companies Act, it started way back in 1985, I think, and it said, for the purposes of the 1985 Act, the word director shall include anybody who occupies the position of director. So a director, doesn't matter, and it goes on and says, by whatever name called. So it doesn't matter what job title the person has. It doesn't matter if the third assistant under secretary to the cleaner, if that's their job title, it doesn't matter. If they turn up in their car every morning and sit in their own office and call for the secretary to come in and take notes, if they enter into contracts, if they operate as though they were a director, then they are a director, no matter what their job title. And it goes on, the definition section continues and says a shadow director. A shadow director is defined as being a person in accordance with whose instructions the directors are accustomed to act. Now, in many situations, that would therefore involve the wife, on the basis that directors will often are accustomed to act in accordance with instructions from higher up. A de facto director is a person who purports to act as though they were a director. I probably don't know the word purport. A person, you do know the word? No. It's a person who holds themselves out as a director. They claim in negotiations with other people that they are a director. I'm a director, for instance, of John's firm. I'm a director there. Actually, I'm not. But if I say I am, and therefore I claim to be in the position of being able to enter into a contract for John's firm, and you have no reason to disbelieve me, then I will be classed as a director, and I will be liable to compensate John for any loss which I cause him by my acting as a director, an unauthorized director. So it's a person who holds themselves out as being a director when in fact they're not a director. Yeah, to pretend. Okay, pretend. Yes, okay. Actually, the technical expression, you will find it in exam questions, is where somebody holds themselves out. Okay. Alternate directors. I have never, ever come across a situation of alternate directors. I know certainly in the British Chamber of Commerce down the road, in your next door country, British Chamber of Commerce there, they had their annual general meeting yesterday, and there was a proposal or a discussion on the agenda as to the possibility of appointing alternate directors. So, for instance, I am a board member of the British Chamber of Commerce down the road, but because they had the annual general meeting and I was here with you enjoying myself, I was unable to attend. What I could then, if the Constitution had allowed it, I could have appointed somebody from down the road to attend a board meeting on my behalf and speak as though they were me. Now, I don't know whether that resolution has gone through or not, or even whether it finished up on the agenda. But that's what an alternate director is. It's someone who I will appoint. In my capacity as a director, I will appoint Benita to attend the board meeting and speak and represent my views. Because I'm not able to attend, I can get somebody else to do it. I have never heard of it happening in practice. Never. I know I may look old, but I'm not that old. And in all these few years that I've been around, I have never, ever heard of an alternate director. What are you grinning at? Executive directors, more on these next, and then non-executive. Executive and non-executive and their different roles has arisen primarily or principally as a result of the recognition of the requirement for corporate governance. Corporate governance itself is defined as a system whereby companies are directed and controlled. And the concept of corporate governance really came about in the early 1990s. 1992 in the UK was the issue of a report by a man called Cadbury, that was his family name, Cadbury, chocolates. We have another case of chocolates. Nestle, yeah. What was the Nestle one about? The sweetie wrappings have a value. Even though you throw them away, they still have a value. What's another word for saying things of insignificance have a value? A peppercorn. What was the woman who was paying the peppercorn rent? Thomas, yeah, Widow Thomas was paying the peppercorn rent. Thomas and Thomas are the same plaintiff and defendant. We've got a list of other same. Well, see how how your thought processes just flow. Do you not see that? It's like the Dow it just flows endlessly. Unless it's frozen. Non-executive directors came about as a result of this recognition of the desirability for corporate governance or a system of corporate governance. And non-executive do not take part in the day-to-day running of the company. This is the role of the executive directors. But the non-executive are therefore independent of the company. They are directors. They're properly appointed. They're properly subject to retirement procedure. But they don't take part in the active day-to-day. They don't turn up at the company on a daily basis. They don't work full-time for the company like an executive director does. But these other people are therefore independent, and they bring independent objectivity. And they act as a supervisory board, supervising and controlling the activities of the executive directors. The idea is to prevent as many as possible high-profile corporate failures. In the back end of the 1980s and the very early 1990s in the UK, we had a number of very high-profile corporate failures where lots of people were financially injured. Employees lose their jobs, shareholders lose their money, pensioners lose their pension because a single tyrannical, dictatorial director has blown the company finances. They've just gone. And now there's no pension fund left to pay the pensioners. There's no work left because the company's in liquidation, and the employees, therefore, are now redundant. And it's not just the employees. It's the employees and all the people who are dependent upon them, their families, their parents, that's part of family, isn't it? But it's also the local shopkeepers and the local bars and restaurants, and the town itself is damaged because this company, this major employer, is now gone into liquidation, and the people of the town, 20-30% of the people of the town, are directly dependent upon this company continuing to pay salaries. And it's bad news, and it really is very sad news. But because of the high-profile corporate failure incidents in the back end of the 80s and the early 90s, the government appointed Cadbury to identify what can be done in order to prevent further failures as much as possible. You can't legislate against a company going into liquidation or becoming insolvent, but at least you can begin to think about seeking to prevent it and managing the risk. And these non-executives are appointed now for public companies. It's a requirement for public companies, but not for private. They're appointed to a supervisory position so that they overlook and control and help to direct the activities of the executive directors. So they're an integral element of corporate governance. They bring an independent view. They help in providing effective leadership. They help to establish and maintain financial probity, fair dealing, honesty, reliability, transparency, believability, credibility. And they keep a watchful eye on the effectiveness of the executive directors. Page 78, number and eligibility of directors, the number of directors and the eligibility of directors. Is that all right? I'm thinking it's nearly 12:30. Am I wrong? Is it only 11:30? It seems to be going on a lot this morning, doesn't it? It is going on. You agree? Yeah. Okay. But that's right. Okay. Number and eligibility. Private companies, there must be at least one director. Public companies, you must have at least two. But anyone can be a director. A company can be a director of another company. It doesn't say much in general meetings, in directors' meetings. It doesn't say a lot. But it's possible that an inanimate, a non-human person can be a director. Could you appoint a horse to the Roman Council? The Emperor Caligula did. He appointed his horse, I've forgotten the name, but he appointed his horse to be a senator in ancient Rome. The man was mad. Anyone may be a director. There are some restrictions. You must be over 16. You may be a non-natural person, so a company. You mustn't have been banned under the provisions of the CDDA, the Company Directors Disqualification Act. The CDDA is the Company Directors Disqualification Act, which is more fully explained on page 79. You mustn't be bankrupt. And if you become bankrupt, then you must leave your position. You must resign as a director. You must not be of unsound mind. Them again? Well, it's difficult to prove, isn't it? But sometimes it's obvious. I mean, you don't think of John. Sometimes it's obvious that he isn't, obviously. You should not be absent without permission from board meetings for a period in excess of 6 months. Well, I find that one a little bit difficult. In fact, I came across it when I was talking to my accountant, who looks after my local language records. I was talking to them and I said, this is ridiculous, because when I created my company down the road, it said within the Constitution, the director, as in there is only one director. Fine, that's acceptable. But it does mean that if my senior employee doesn't have written authority and I'm in an accident in hospital for 3 months in a coma, it means the company can't do anything. It just stops. It can't operate, it can't draw money, it can't pay wages. It just has to stop, which is stupid. I think that's a stupid piece of legislation in the country where I now live. And I think it's now changed. They now allow me to appoint a procurer. Yeah, I can appoint a procurer, and a procurer can do effectively anything that a director can, but they can't put the company into liquidation. But otherwise, I think they can do pretty much anything. Now, a procurer in the language down the road is rather different than a procurer in the English language. The English language, a procurer in England, would be someone who I employ to find me young women in order to satisfy my natural urges. So I would pay someone, Eddie, can you procure some fresh acquaintances for me? Then I would appoint you as my procurer in England. But a procurer down the road is a person who operates as though they were a director. So you've got to be careful with the use of words. Don't go to England and say, I want to become a procurer. I think I'm on page 79. Yes, I'm on page 79. The Company Directors Disqualification Act. Piece of legislation which has been passed in order to give the courts the strength, the authority, to say to people who it is alleged have broken basic rules, it gives the court the opportunity to say to these people, you're not fit to be a director. We're going to ban you from being a director, from holding the office of director by whatever name called. You may be classed as the assistant purchasing clerk, but then if you operate as a director, you're in breach of that court order. So the CDDA allows the court to ban people as directors, and there are some very high-profile people who have been banned by the UK, by the English courts. I'm thinking of a man who was the former manager of the England football team, a man called Terry Venables. He's been banned as a director. He's not a fit and proper person to hold the position of director. And there are two very famous comedians, or famous in the UK, a man called Cannon and his friend Ball. And Cannon and Ball have also been banned from being directors. Again, it's football orientated, but high-profile people are subjected to court hearings, and if the court determines that you're not fit to be a director, they shall ban you. The period of the ban, all right, let's look at the offences. For an offence committed, if you commit an offence in the promotion, formation, management, liquidation, or destruction, striking off a company, then you may be banned. Who's going to take you to court? Who is going to take you to court? Yeah, the company may do. The shareholders acting through their majority may do. I'm thinking particularly of things like management, liquidation, or striking off. Would be an administrator, or a receiver, or a liquidator, or a Department of Trade inspector may come along and determine that you are guilty of wrongful acts and therefore sue you and take you to court and ask the court to find you guilty as being not a proper person, not a fit and proper person. If you're persistently in default, and persistent is defined as 3 offences in 5 years, with reference to the filing of documents with the registrar, you have to file an annual return. As a director, as companies have to file an annual return every year. But you must also file notice of your agenda of an annual general meeting, and you must file copies of your special resolutions, and you must file your constitution and the memorandum, and you must file any document which identifies a change in the directors, even a change where your director changes name and gets married, for instance. You have to notify the registrar. So if you are persistently in default of these filing requirements, then on application to the court, probably by the registrar or the Department of Trade, the court may ban you for a period up to 15 years, it says later. If you're found guilty of fraudulent or wrongful trading, now I mentioned fraudulent or wrongful trading yesterday, and I did distinguish them because they are 2 separate criminal offences. What do you understand by fraudulent trading? Bernita. Jana. It's setting up a company with a specific intention of defrauding creditors. That's what fraudulent trading is. Wrongful trading, and I wrote this on the screen, wrongful trading is allowing the company to continue in operation without there being a reasonable prospect that the company will be able to avoid an insolvent liquidation within the foreseeable future. What's the foreseeable future? How far can you foresee your own life? You can? You know where you're going to be in 12 months' time. I don't even know where I'm going to be this evening. How far can you foresee where you will be in 12 months' time? Well, you certainly won't be listening to law lectures. You'll have passed that in June. Okay, so if you're found guilty of fraudulent or wrongful trading, then the courts will ban you. If you're involved in a company's insolvent liquidation twice, you're allowed to be involved once, but if you're involved with an insolvent company or insolvent liquidation twice within a period of 5 years, then on application a liquidator will take you to the court and the court will ban you. Following a Department of Trade investigation, they've investigated what your activities have been, what you're doing, whether it looks like you're above board and clean and honest, and if the Department of Trade says you're not, they will take you to court and the court will ban you. In general, the disqualification period is up to 15 years. There's one offence, I can't remember which of them, there's one offence which says anywhere between 5 and 15 years. But generally, if I was facing this in an exam, I would say a CDDA order, a company director's disqualification order, can be for any period with a maximum of 15 years. And then finally, if you break the disqualification order, if you're in contempt of court, the court bans you from being a director and you say, I'll start again and be a director again. If you're found out, you face 2 years in prison. If you're not found out, well, you're being basically dishonest and immoral and unethical, but if you're not found out, it's like driving offences in this part of the world. You can do anything you want. You can go through red traffic lights, drive up the one-way street, you can ignore traffic signs, and everything's fine unless you're caught. All right, aren't I? Innocent until caught, or innocent until proved guilty. Page 80, directors, still appointment. The first directors, these people are named by the promoters within the documents which are necessary to be filed in order that the company shall be created. So details of the first directors will be given in that paperwork. And then subsequent directors, well, how may directors, exam question, how may directors be appointed? And the answer is by shareholders, by members in general meeting. But that's not the end of it. There are other people who can appoint directors, and you've got them listed here on page 80. The existing directors, if there is a vacancy on the board of directors, the existing directors can appoint another person. So that person does not have the support of the members, so the 4 of us, the directors here, may choose to appoint Madara as a new director, because our board of directors could be 5, there are only 4 of us, let's appoint Madara to make up the 5th person. But whereas we 4 have been appointed by the shareholders, the members in general meeting, Madara hasn't. She's just a friend of Jana's, and she gets appointed on that basis. That type of director, who is appointed by the existing directors, that particular director must resign at the next general meeting of members, and if they want, they can then submit themselves for re-election. So they do get the approval of the members, but only after we have appointed and Madara has served on the board for 3 months. Then we have the general meeting of members, and the members have got the opportunity to decide, do we want Madara on our board of directors? And the members will make that decision. The court can appoint directors. It's desperately rare, but they can. The court can say, you, director of that company. So it's a strange situation, and I don't know of any circumstance where that has happened. A lender. A company wants to borrow money, and the lender says, yes, okay, I'll lend you some money, but I want my loan to be protected. I want to have the opportunity to have representation on the board. I want my representative to appear on your board in order that my investment, my loan, then has some element of protection. And there are cases where it is potentially available. Listen to this. It's potentially available that these 3 directors in their company want to borrow some money. They ask me, and I say, yes, I'll lend you some money, but I want to appoint these 4 as directors. So these 4 then join the board of directors. These 4 are my representatives, and I have got control of your company. And so it is potentially available. I've never heard of it happening, but it's potentially available for a lender to appoint a majority of directors. I've never heard of it. So far as I'm aware, it never has happened. But it's a case called Re A and B C chewing gum. Chewing gum. You know, the stuff that you find stuck under the desks. What a filthy habit that is. And it's not unusual for me to lecture like this, and every now and then I've got chewing gum on my fingers. A dirty habit. So Re A and B C chewing gum was an example where an outside lender had the opportunity to have a representation on the board. The 2 directors were 2 brothers, Douglas and Anthony Coakley. And Douglas and Anthony approached this lender. The lender said, yes, I want representation. And Douglas said, I will represent your interests. Okay. And then the lender got a little bit upset with Douglas and said, I don't want you to represent my interests. I want Christina to represent my interests. And Douglas said, no, I will represent your interests. And if you don't want me, then you can have Anthony. And if you don't want Anthony, then you can have me again. And if you don't want me, you can have Anthony. But you can't have an outside person coming in. And he went to court. And the court said, well, why not? Why can we not appoint Christina to the board in order to look after my interests? So that was the case Re A and B C chewing gum. An administrator. An administrator is a strange person. They get appointed to take over the control of a company in difficulty. The company sees it's in difficulty. We're either facing a protracted long period where we're not likely to be successful and we'll go into liquidation. But if we think the company is worth saving, we can appoint an administrator. And the administrator will come into the company and they will take control. And the authority of the existing directors is moved sideways. And this person steps in and takes over the reins of control. And hopefully they will be able to turn the fortunes of the company round, make it profitable again, and then pass the control back to the directors. So that's what an administrator is. Because he's got control, he can appoint directors to help him run this company in difficulty, to try and get it out of its difficulty. A 1/3 rotation procedure. There are 20 of us, the directors of a company, and the 1/3 rotation procedure says that apart from Madara, who has to submit herself for re-election because she was appointed by the rest of us during the year, she has to resign at the next general meeting. But you can't have all 20 resigning at the next annual general meeting. So a 1/3 procedure is required. And of the 20 of us, take off Madara, that's 19 of us, the number nearest to 1/3 of those 19 will retire on a 1/3 rotation procedure. So 6 of us will retire this year, and then a different 6 will retire next year, and then the other 7 will retire the year after, and then 6 of us retire, and so on. And it just rotates. And it gives the shareholders the opportunity on a regular basis to determine whether they want to continue using the services of Liena or whether we don't want to. So the resolution to reappoint Liena, who is a director retiring by rotation, all those in favour? No one? Those against? Oh, sorry, Liena, you've lost your office. You're no longer a director. If the company is a top FTSE 350 company, if it's in the Financial Times Stock Exchange list as being one of the top 350 companies, then all the directors must retire every year, which is new. It's a new requirement, this corporate governance requirement. Directors are appointed by ordinary resolution. What sort of majority do you need for an ordinary resolution? One more vote in favour. You need a majority, therefore. One more vote in favour than votes against. So it is as easy as possible to appoint a director, so long as the wishes of the majority are that this person shall be appointed, then they will be appointed. What sort of resolution do you think you need to remove a director? To get rid of them, to vote them out of office. Not simply not re-elect them, like I did with you just now, but actually to move them out of office. We're between general meetings. It's not the opportunity. Even if it's the opportunity at the next general meeting, it may be that Ganuta is not up for retirement, up for re-election, and we want to get rid of Ganuta. It's an ordinary resolution. Simple as possible. One more vote in favour than votes against. It's an ordinary resolution to get rid. It's an ordinary resolution to appoint. And the registrar will be notified. Clearly, we've got to keep the registrar up to date with reference to the personal details of our directors. The registrar needs to be told their date of birth. It's a peculiar thing in the UK that the registrar has got all these directors and they know the date of birth, and the registrar sends a birthday email to the directors. So again? Congratulations on your birthday, yeah. What date is it today? 1st of April, is it? No, the registrar does not send a birthday telegram or a birthday email. The reason why dates of birth are required is because for a public company, a director who reaches the age of 70 shall retire. Now, they can stand for re-election, but that requires a particular type of resolution. It is an ordinary resolution, but it has a little bit of peculiarity about it, which I'm not going to tell you just yet. But once a director of a public company reaches the age of 70, they must retire, and they must retire each year. Not only must you give things like your home address as a director, and your occupation, which people often write as director, which is a bit silly. Not only must you give your home address, unless you claim that it would be dangerous to give your home address. Terrorism, people who disagree with the activities that the company you're a director of. If your company is involved in drugs testing on animals, then the Animal Welfare Societies, the Animal Rights Association, could very well come along and damage your personal property. Could very well throw smoke bombs or set fire to your home because the animal welfare people are committed people and their ideals are uncompromising. So it may be dangerous, or you may claim that it's dangerous, to give your own private details of your residential address, in which case then you would give the address of the company. Not only that, but the document which you send to the registrar has a space on it and it says consent signature. So a director who is appointed, a new director who is appointed, has to give their written consent that they are happy to serve as a director of the company. Otherwise, I could appoint you without your written consent. I could appoint you without your knowledge. You should just appoint Eddie without him even knowing. And Eddie now is a director of the company, and he doesn't know this, but then he starts assuming liability. Because if he's a director of a company which goes into an insolvent liquidation, there he is. He didn't even know he was a director. So they have to give their written consent to act.